Right.
Thank you. Everybody have a seat. We have some prisoners transported today from Department of Corrections prisoners, is that correct?
Miller, William Miller.
Are you William Miller?
Yes, I am.
Good morning.
Good morning. How are you?
I'm blessed. I hope you are too. This is 25 CR 0025. Mr. Miller, were you born in 1980?
Yes.
Last four digits of your social security number 2359.
Yes.
We're here for a pretrial conference. What does the Commonwealth have to say?
I believe we have a felony plea. Is that correct?
That is correct.
Mr. Miller, a motion, I've just been informed of a motion that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person that we just identified in 25 CR 0025?
Yes.
Is your judgment impaired today in any
No.
way? Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case? Do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go through the rights and then I'm going to ask if you understand. If anytime you have any questions, you can step away and talk to your attorney, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial, but jury, your right to be represented by counsel to jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court. If you lose, you have a right to require the Commonwealth prove beyond a reasonable doubt you're guilty of charge against you. Understand that by entering guilty plea today, you give up those.
Yes.
Okay, now I may consider the Commonwealth's recommendation that I'm about to hear, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will have a pre-sentence investigation report done by probation and parole. In the event after reviewing the Commonwealth's recommendation in that report, I decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that?
Yes.
You step to the left slightly, and Mr. Judd, are you going to come forward? And Mr. Miller, listen carefully to what he has to say here, okay? Go ahead, Mr. Judd.
The Commonwealth agrees to dismiss giving police officer false identifying information, KRS 523-100 Class B misdemeanor, and also failure to signal, which is a violation, and operating a motor vehicle while license is revoked or suspended for driving under the influence, Class B misdemeanor. Upon a plea of guilty to possession of a controlled substance first degree, methamphetamine, the defendant shall receive a sentence of 1 year to serve. This 1 year sentence shall run consecutively to Monroe Circuit Court Indictment Number 22 CR 00104. The Commonwealth opposes probation and shock probation. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth of Kentucky.
Sir, is that your understanding of Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged in the amendment, in the indictment as amended?
Yes.
You doing so of your own free will?
Yes.
Okay, knowing your constitutional rights, still your desire to proceed and allow the court to fix your punishment according to law.
Yes.
You understand, but entering this plea, any future convictions will be enhanced on a persistent felony offender law. Is that your signature on the plea agreement?
Yes.
Okay, I'll accept the plea agreement and we will schedule sentencing for November the 13th, which is hard for me to believe it's November already. You know?
Your Honor, if I may, he is a state inmate, and we are willing to waive the PSI this time and ask for him to.
Okay, he has been continuously confined since the last sentencing, so we'll waive it, we'll enter the sentence today, so you won't have to. But I mean, if you want to come down.
No, I don't like riding 3.5 hours like this. You
Yeah,
know?
I understand. Well, you get to see the neighborhood, you know.
Yeah, I mean, it's good to see home, but still, yeah, but
Well, I hope you
yeah.
want, Yeah, I hope you can turn things around, man.
I'm going to. I
Okay,
got three youngins out here that says I got to.
okay, well, they're sticking with you. And a lot of people don't have anybody, you know?
Thank you, Your Honor.
Yeah, here's that envelope there. Go with it. Thank you. Now, who's the next person we have for corrections has here?
Waiving court costs.
Pardon?
Waiving court costs.
Yeah, I'm gonna waive, consider length of since I'm waiving court costs. Okay, who do we have now from, that's been transported by the Department of Corrections? Yeah. Give me a name here.
I would think.
Robert Tabor, Your Honor.
Yeah.
Robert Tabor. Good morning. Are you Robert Tabor? Mr. Tabor, were you born in 1987?
Yes,
Last four digits, social security number 3597.
yes, sir.
We're here on 25 CR 0043. A motion for release of records, is that right?
That's correct, Your Honor. We had.
I'm not objecting, Your Honor.
Okay, well, when we have something like that, it'd be good if we do an agreed order on that, because this gentleman's had to drive down here. I mean, what's the deal?
Your Honor, we were needing Mr. Tabor transported down here regardless. We have not been able to make contact with him to go over.
Well, we don't run a taxi service. Part of your representation is for you to meet him up there. So we'll sign the order and we'll do it. Mr. Tabor, I hope you have a good trip back up there. Sorry to inconvenience y'all.
Your Honor, if I could, I've spoken to the individuals from the transport staff. There is a form that they have for the court, if the court is willing to sign, that would keep him in Barron County while.
I'm
we're
not gonna
working
get
this
involved
case.
in that. I'm not gonna get involved in that. This is Department of Corrections decision. I'm not gonna start ordering them to move people here, there and yonder. You know, they got enough problems already. I'm just not gonna do that.
I understand, Your Honor, this would.
I'm not gonna
likely-
do that. Thank you.
Thank you, Your Honor.
Yeah. Okay, who else do we have? What's your name, sir?
All stout.
Marlon Stout. Well, good morning, Mr. Stout. This is 23 CR 007. Mr. Stout, were you born in 1995?
Yes, sir.
Last four digits, social security number 8009.
Yes, sir.
You're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Stout has a 10-year sentence on theft by unlawful taking. He was revoked in Barron County. Is he going to stipulate?
He is, yes.
Okay, stipulate, we'll just, and then it's gonna run concurrent with that Barron County time?
It is, yes.
Okay. Okay, we'll sign the order.
All right, thanks.
Judge, on Mr. Tabor that we had here earlier, we didn't set any future court dates.
Well,
He was just for the motion for release of records and on for free trial today.
There's no future pretrial on that.
Right, that's what I'm saying, we didn't say anything in the future.
I don't mind if we want to say the 7th and the 21st or 7th and the motion date.
Hang on a second.
that was the previous week.
It was Mr. Tabor.
Oh, Mr. Tabor, will, what's the negotiation date?
November 7th, 9.
November 7th. And the next court date is November 13th. So we need to put that on the order.
That's why I was
Okay.
asking.
Okay, that'll be on the,
Just hang on a second.
they don't have all that. See if they have the paperwork on both of those people back
They
there.
don't on Mr. Tabor, I'm doing it.
We're doing Mr. Tabor's paperwork now.
What that gentleman showed me, the body receipt has it. Have no paperwork over the flyers.
Yeah. All right.
I,
If they plan on, well, they did if I signed it. Was that the one?
Didn't need to sign.
You what?
Robert Tabor, he said he didn't need to sign. The officer did, so.
I've got his document here.
This is actually stout. You can-
The stout. Wait.
Okay, yeah.
So it always happens when we take people out of order. It starts confusion, you know.
I'm sorry.
I know, you know what I mean? No good deed goes unpunished. does it?
Absolutely. I agree.
Okay, Brian Cook. Brian Cook. No. You think they're planning on leaving one? Brian Cook. Commonwealth versus Brian Cook, 20 CR 0053. Are you Brian Cook?
Yes, sir.
Good morning. Were you born in 1972?
74.
They got you on here wrong. You just gained 2 years right there.
Yeah.
Yeah. And this is his last 4 digits, social security number 7126.
Yes, sir.
This is a shock probation revocation. You moved your left a little bit, sir.
Your Honor, Mr. Cook has a 3-year sentence on possession of a controlled substance, first degree on October the 5th. He was stopped for DUI in Barron County. He was stopped by the officer. We have the video cam. He blew a .270 and we're asking that he be revoked. I've had the officer here to testify. This,
Okay. Y'all want to stipulate?
Your Honor, we are stipulating to the factual allegations. He did
Okay.
pick up that charge.
You want to be heard then?
Yes, Your Honor. Mr. Cook does want to testify as to some mitigating information for the court leading up to the DUI charge.
Okay. So you don't need to present any proof, but we'd like the officer to stay around just in case. Okay. Just for a second, then we'll release off. You have your right hand, please. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
You may proceed.
Mr. Cook, you are not currently in any way contradicting the allegations that have been made against you, correct?
No.
So, Mr. Cook, can you explain to the court what was happening in your life immediately leading up to picking up this DUI charge?
My mother's husband, they've been married for 25 years. He got deported to Honduras and he sold the house up in Honduras. In 30 days, I had to figure out how to take care of her. Well, was taking care of her and I just I had to slip up. Went out, had a few drinks, got stopped.
And you acknowledge that this was not the correct course of action to have
No.
taken?
No,
Mr. Cook, if the court was to give you another opportunity to be released onto your supervision, are you willing to comply with any conditions that he has placed on you?
yeah,
And rather than taking this course of action whenever things go wrong in your life, are you willing to talk to your probation officer about maybe support resources?
yes.
Okay, I have no further questions.
You don't have any questions, do you?
I don't have.
Okay. Well, one of the great fears that any judge has is to have somebody on probation, shock probation, or pretrial release or bond that gets out and has a slip. You didn't just have a few drinks, you had a lot of drinks, to testify that. And you get over and run over a school bus and the first thing they say, well, why in the world did that judge let that guy go? So, you knew what the conditions were and I don't want to be mean to you, okay? I can't overlook that. And so I hope you can turn things around. Okay, thank you very much. Motion for shock probation denied. Okay, who, I guess we got Justin Gillespie. Justin Gillespie. Commonwealth versus Justin Gillespie, 25 CR 0049. Are you Justin Gillespie?
Yes, sir.
Good morning. We're here on 25 CR 0049. Were you born in 1985?
Yes, sir.
Last 4 digits of social security, 5237.
Yes, sir.
We're here for sentencing.
Judge, I would ask the court to put out sentencing for 1 month because Mr. Gillespie's had trouble in the special court. He wouldn't test, and he absconded, and he got caught. And I don't know if we're playing yo-yo back and forth with drug court, but they didn't terminate him this morning. So I don't know if they're planning on taking him back or what, but if they don't, I don't know what to do in this case, to be honest, because he's not done what he's supposed to as part of our agreement.
I was trying to get him
Hold on,
sorry.
don't say it. Judge, I also would ask if we could continue this, so that I can speak further with Mr. Gillespie and Mr. Stockton about what options that we.
What were the violations he was accused of?
He was, 1, he didn't test in drug court, and 2, he absconded. He got picked up on the warrants, my understanding, is that right?
How long was he gone?
No. And I don't have the paperwork from drug court, so I don't know, I'm counting that law something.
Whose dime is he on now?
He will be on the county down until he's sentenced, so.
Yeah,
All that in consideration.
I'm not real big on somebody being in drug court, not complying and then charging Monroe County.
The sentence that he's to be received today is your That's complicated. You sentencing to go back.
If he sentenced today, he goes back to drug court.
That's,
Well, if he's sentenced today and he's probated, you can do whatever conditions you want, or you can sentence him and not probate him, or you can delay sentencing. So guy thinks about the three options, the only three options. we have.
it's 3 years since probate for filing drug court is the sentence.
Yeah, that's,
And he violated it. And
Say
so
my
instead of seeking a violation on the probation, you're seeking you're dealing with whether drug court's gonna violate him, which I don't know why we couldn't address, he violated his probation.
He's
that's
not,
correct.
is he on probation?
He's not
He's
on
not
yet,
on.
and I guess this is the issue.
Well, how is he in drug court on pretrial?
Well, I don't know, how. I guess they went ahead and got him in and oriented him before the sentence. I guess is what happened.
And Your Honor, if I may, I believe he had only been out for just a couple of weeks leading up to that.
Just a couple of weeks.
Just a couple of weeks.
Yeah, that's because they caught him.
Judge, if I may.
Yeah.
Part of drug court, if they have problems, we look at the fact of sending them to rehab, a long-term
But
rehab.
what was he doing? How did he get in drug court? Did he enter a plea here?
The interplay he's on for sentencing today.
Okay,
And they must have,
so they went ahead and got him into drug court early. Is that what? You're on drug court board, aren't you?
Correct.
They got him in drug court early.
But all of this
And he
happened.
violates before he can get sentenced.
Correct.
Yeah, this is one we did information indictment.
Oh, rocket docket, I see.
That's probably the reason.
Yeah, I understand it now. I'm gonna revoke your probation and we'll skip.
he's on.
I'm gonna sentence you today but I'm not gonna probate you.
Your Honor, if you are rejecting the agreement that we had reached with the Commonwealth, we would request to withdraw that agreement. at this
Okay,
time.
well, we'll schedule him for trial, right?
Yes, Your Honor.
Okay.
There it is, yeah.
I was gonna shock probate him, but that's okay. Let's get calendar out. I'll tell you what we got.
It's a possession case of immediate to have.
Uh, How about March 4th?
You said March the 4th.
He did.
That date is fine with me, Your Honor.
Do we need a negotiation day? No.
That's me. That one's across the flat, is that? All right.
Okay.
Okay, let's take care of it. What's the number on it?
25 CR 49.
Timothy Jackson. Commonwealth versus Timothy Jackson, 25 CR 0048, 25 CR 31. Are you Timothy Jackson? Good morning. Were you born in 1984, Mr. Jackson? Last four digits, social security number 9460. We're here on a pretrial conference on both those cases. What does the Commonwealth have?
Your Honor, I believe there's been a mediation order entered on these two cases and his Cumberland. Yes.
Yeah.
So we can just pass it for a few months, so we have an opportunity to speak.
You want to go out past December?
I would think December, let's try that.
December the 15th is your next appearance, okay? And you're in, and the other cases in
Cumberland County.
Cumberland County. So, well, that's, you can handle both roads and we can actually can combine for judicial economy if we have to. Okay, say to pick up some days. Jarvis Morris. Commonwealth versus Garvis Morris, 25 CR 0038. Are you Garvis Morris? Good morning, sir. Were you born in 1970? Last four digits, social security number 0839. We're here for sentencing today. Have you had an opportunity to review the pre-sentence investigation report done by probation and parole? Go over it with your attorney?
Yeah.
Okay, is it substantially correct?
Yes, sir.
Okay, upon a plea of guilty to assault third degree, the defendant shall receive a sentence of 5 years, serve 120 days in jail with a balance probated for 5 years supervised. He will be referred to the social service clinician and following recommendation. All evidence is to be destroyed. Court costs are $215, and I'll give you some time to pay that. You can pay your first $30 payment 30 days after your release from custody. How far into his 120 days is he?
Your Honor, I think he owes like 6 days.
6 days?
I believe so.
Okay, well, your court costs start running 30 days from that date. Well, you gonna go visit him probation and parole over in jail before he gets out to?
Yeah, yes, Your Honor, I'll go see him Monday and.
Okay, that way they can get you ready on time, okay? Okay, thank you very much. Jody Murphy.
She was the one that was not transported, but. She was the one that was supposed to be back.
Okay,
Your Honor, could
okay,
they
we'll
pass?
just, she can renotice that motion for the November rule day. Ashley Pittigo. Commonwealth versus Ashley Pittigo, 24 CR 0046 and 25 0056. You are Ashley Pittigo. Good morning.
Good morning.
Were you born in 1991? Last four digits, social security number 1720. We have an arraignment to do here first. The grand jury of Monroe County has returned an indictment or information rather, charging you with possession of controlled substance and possession of drug paraphernalia. You acknowledge the identity of your client, waive formal reading and arraignment, and you're about to enter a plea. Is that correct?
Yes, Your Honor.
Were these felony pleas?
Yes.
A motion has been tendered that says that you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
Yes.
Is this plea freely and voluntarily given? Are you the same person that we just identified, 24 CR 0046 and 25 CR 0056?
Yes, sir.
Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes.
Have you reviewed the evidence Commonwealth has against you?
Yes,
You believe that you've been fully informed about this case.
yes,
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything, right to speed trial, but jury right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in favor, have process issued, compel their attendance. You have a right to appeal this matter to higher court. If you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty, charged against you. Understand about entering a plea in this case, you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation prior to accepting any recommendation. I have a pre-sentence investigation report done by probation and parole. Then I don't accept the recommendation and decide to impose a harsher sentence after having reviewed that report. You have the right to withdraw your plea of guilty and proceed to trial. You understand that? If you move to your left a little bit, please. Mr. Judd, what is the Commonwealth's recommendation as to Ms. Pettigo?
Your Honor, please, the Commonwealth agrees to dismiss possession of drug paraphernalia, KRS 218A 502. Second, upon a plea of guilty, possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2 years probated for 5 years supervised. The 3-year sentence shall run consecutive with Monroe indictment number 24 CR 00046. The defendant shall enter and complete the Monroe Specialty Court. The defendant is incarcerated and shall be released the morning of orientation. If orientation is before final sentencing, the defendant shall be released to begin the program. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above case disposed of in a manner in accordance with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment or information as amended?
Yes, sir.
You're doing so your own free will. Constitutional rights have been explained to you, still your desire to proceed and allow the court to fix your punishment within the range of the law. You understand that after entering this plea of guilty, any future conviction will be enhanced as far as the range of penalty under persistent felony offender law. You understand that? Is that your signature on the motion and offer? Okay, well, I'll accept it in order, a PSI done. We scheduled since November 13th. Now, how long have you been incarcerated?
A month and a week.
Yeah,
A little over a month.
do you have any underlying medical conditions of any kind?
No, sorry.
Okay, so you're ready to get into this drug court thing and really try.
Yes,
okay?
sir.
Well, I'll see you on the 13th and I hope it goes better for you, okay?
Thank you.
Okay. Damian Tackett. Damian Tackett. Is it Damon or Damian?
Daniel.
Damien. Good morning, Mr. Tackett. You're here on 25 CR 0019. You born in 1984?
Yes.
Last 4 digits, social security number 4520. Says we're here for review, Mr. Stockton.
It's actually a motion to revoke probation, Your Honor.
Okay.
Mr. Tackett has a 5-year sentence on criminal mischief first degree. And my understanding was he was basically homeless. Mr. Collins helped him get some clothes and things, and then he went to the Phoenix Project for housing, and he didn't stay but a couple of days and left.
Your Honor, last month we did have the hearing on this, took it under advisement. I've been out for the last 2 weeks. I'm still working on, I believe the last part is get him housing, get him a job, and then he would agree not to revoke. I'm still working on that. To be able to see if there's a halfway house. I don't believe sober living is appropriate, and then getting through the job. So I'm still working on that with our ASW.
But your ruling last time, if you not getting the job where you could pay restitution. Any prospects.
I would just ask for a little bit more time, Your Honor. I apologize.
You're saying it was your problem and not his because it's like, is that what you're telling me?
100%, Your Honor.
Well, I'm going to accept that. You know, you I'll accept that. We'll take another look at it on November, in November, if he had been dilatory in some way, if the defendant had been dilatory. But, you know, you got a great responsibility as a public advocate to do these, and I expect you to have it done and tell us what's going on,
Yes, sir.
by November 13th.
Yes, sir.
Okay. Dakota Williams. Yeah. Commonwealth versus Dakota Williams, 25 CR 0045. Are you Dakota Williams?
Yeah.
Good morning. Were you born in 2003?
Yeah.
Last four digits, social security number 4741. You're here for sentencing. Have you had an opportunity to look at the citizens list? Is it substantially correct?
Yeah.
Okay, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty to criminal mischief, the deed shall receive a sentence of 1 year. 1 year shall run consecutively to Monroe Circuit Court 22 CR 0021 rather, CR 0019 and CR 018. The defendant agreed to stipulate on the revocation of 21, 19, and 18 Commonwealth post probation. So the court costs are $215. And I'll give it, when you get released, you can start paying $30 a month. So, you know, so it's something you can do, okay? 30 days after, that's a $215 court cost, okay? Thank you very much. Now we got out of custody people. Rick, hey, Nathaniel Metter. I did skip over Nathaniel Metter. Nathaniel Metter. Commonwealth versus Nathaniel Metter, 22 CR 0017. Are you Nathaniel Metter? Are you Nathaniel Metter?
You gotta say it loud on the right side.
Yes, sir.
Okay, good morning. Were you born in 1997?
Yeah.
Last four digits, social security number 2309?
Yeah.
You're here on a probation revocation. What does the Commonwealth have to say?
No, this was 5 year sentence, and last time we did a drug court referral order, and he is eligible if the court wants to put him in. He had an AI, was a violation on probation.
You want to do drug court?
Yeah.
Well, that's a bad question. Nobody wants to do drug court. Had you rather do drug court than go to the penitentiary?
Yeah.
Okay, well, you know, you'll need to make a certain commitment to drug court. You know, you can make it through it. All you do is like, you know, not get in any trouble, get a job, you know, pay your obligations. So I'm going to go ahead and refer you to drug court, see if they'll accept you in, maybe turn things around.
Yes, sir. I
Okay.
believe he's been assessed and he's been accepted, and we do have the waiver that I can turn into.
Yeah, have a waiver.
The SPC 3 waiver of specialty court that I believe that drug court requires.
It has to be turned in the clerk's office.
Yeah, well, I don't, we,
No,
Okay.
it's the defense counsel who does turn it in.
yeah, I didn't think I ever signed any kind of thing like that, so. Okay, well, I will let you out on the day of your orientation. Has it been set, orientation date been set yet?
I'm not sure.
Okay, well, you'll get out that morning, so do you live here in Monroe County?
Yeah.
Yeah, well, if they said it, we'll let you out that morning early enough in case you want to go change clothes or something, in case you don't have suitable clothes with you over there, okay? Okay, thank you.
Thank you.
Okay, Ricky Birdwell. Commonwealth versus Ricky Birdwell. 25 CR 0053. Are you Ricky Birdwell? Were you born in 1979?
Yes, sir.
Last four digits of your social security number is 0838. You have an attorney? She have somebody in district court? She go through district court? Is this a direct submission?
The direction. That's correct, indictment.
Yeah. Have you filled out a form yet? Okay, fill out a form, see if you're, are you okay? Are you okay? Are you sick? What's wrong with you?
I have large pain in my leg and my back.
You have
I
what?
have spinal stenosis. and-
Well, I don't want you to have to tell me what's wrong, but I mean, is this a normal condition for you?
No.
Are you taking medication right now?
But not
You
Nothing.
have a prescription for it?
It's just ibuprofen 800 and, Gabapentin, yes.
Okay. If you fill out the form, we'll see if you're eligible for a public defender. Mark Brown, active warrant.
He actually was in Barron County Jail, Your Honor.
Serves the warrant's been served.
Okay, so we'll move him down to Barron County Jail. Larry Buttram. Larry Buttram.
Yes, sir.
Okay. You need to turn your camera on, Mr. Buttram.
Okay.
Where is Mr. Buttram?
He's in jail, Judge.
Where?
Barron County. We're on final.
We had him on out of custody. I'll go ahead and do it, I guess, but
We're ready to go. He's reviewed his.
Commonwealth versus Larry Buttram, 25 CI 0050 here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report, Mr. Buttram?
Yes, sir.
Substantially correct? Is it?
Yes, sir. Yes, sir.
Is there any reason why this gentleman shall not be sentenced?
No, Judge.
Upon pleading guilty to possession of controlled substance, first offense finished to receive a term, 3 years, probated for 5 years, shall run consecutively with 24 CR 0093. He shall enter and complete long-term treatment facility, remain incarcerated the morning of the bed date, transported by probation and parole. Receive credit for time served. Court costs $165 to start paying it $30 a month, 30 days after he is released. What is this other case that he has that you're running this with? Says it shall run
That was another possession.
consecutively.
Kind of like Miss Pettigo's case, he had a previous possession. And I added time to this case so he could, but go long.
Okay.
Judge, the only thing I'd ask the court, I think probation and parole advised maybe that they was gonna have Darnell Bertram take him to treatment, or is that not correct?
Yeah, I spoke with, I guess it was his mother. She said she was the wife. She said she would take him. She called me and wanted to know if it'd be okay. She can transport him straight from the jail.
It doesn't matter to us, but I just wanted to bring it up to you because you make the final decision on.
What does the Commonwealth have to say?
I don't mind who takes him. The problem is if he just needs to get there and stay.
Is that you, ma'am? You gonna transport him? Well, you realize if you need to make sure your car is clean of any kind of drug paraphernalia or weapons or anything. You understand that? Okay. I'm gonna take a chance on you. Okay. Yeah.
Judge, the court costs were
$165. You start paying $30 a month, 30 days after he's released. Christopher Deweese. Christopher Deweese.
Your Honor, we gave this for Mr. Deweese. Your Honor, Mr. Deweese broke his leg. His family members saw Mr. Stockton. He just had surgery again yesterday.
What do you say, Mr. Stockton?
I'm agreeing to pass this case.
November the 14th?
Yes, sir, please. Thank you, Your Honor.
Yeah.
We probably ought to put in negotiation.
I don't, yeah,
Maybe he can
yes,
attend the
he may have to
finals.
attend by phone.
November 7th for negotiation, November 13th, the next court.
Yes, sir. Thank you, Your Honor.
Yeah. Mary Gerald.
As far as I know, she's in Hickman County Jail in Tennessee. We've got her in NCIC, you know.
Okay.
Senate deal. That's where that place is.
Tiffany Hitson. Active warrant. Tiffany Henson, so you said active warrant on the
Yes. We'll put her in NCIC.
Daquan Howard. Commonwealth versus Taquan. Is it Taquan, excuse me. Commonwealth versus Taquan Howard, 25 CR 0012. Mr. Howard, were you born in 2004?
Yes, sir.
Last four digits, social security number 1655.
Yes, sir.
Okay, we're here for several reasons. One of them is arraignment.
On the new
Who
indictment.
received the
Yeah,
indictment, you
yeah.
filed that motion. so
The
I did
grand
that.
jury of Monroe County has charged you with aggravated traffic and controlled substance in the first degree. I don't know whether I've ever seen that charge really before. You acknowledge the identity of the client received indictment, waive formal arraignment and enter a plea of not guilty at this time.
Yes, sir. Judge.
Okay. What does the Commonwealth have to say about
We
this?
have a felony plea. We're just trying to figure out if the plea was done on the new indictment or the old indictment.
Well, we'd waive any restrictions. We got the plea done. We're ready to go unless y'all want to move it to November
Well,
13th.
Is it fentanyl?
Yes.
Yes, they just added this charge to the old indictment, so. they're both the same case.
So it'll be fine. We'll just have to dismiss it.
I think I did on the plate.
Yeah. I just want to make sure.
I didn't see that, but it might be.
Motion has been tendered, says you wish to enter a plea today. Is that correct?
Sure.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 25 CR 0012?
Yes, sir.
Is your judgment impaired today in any way?
Yes, sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about this case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you fully understand these rights.
Yes, sir.
You have a right not to testify against you yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses, call and testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose. And right to require the Commonwealth to prove on reasonable doubt that you're guilty charged against you, that you understand that by entering guilty plea, that you give up all those rights.
Yes, sir.
Now, and I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I'll wait the pre-sentence investigation report done on probation and parole. In the event that I want to decide to give you a harsher punishment, you have a right to withdraw your plea. What is the Commonwealth's recommendation? Step you up a little bit.
Your Honor, the Commonwealth agrees to dismiss trafficking and controlled substance, first degree of cocaine. It's a Class C felony, 5 to 10 years. Also possession of marijuana, a Class B misdemeanor, possession of drug paraphernalia, a Class A misdemeanor. To amend aggravated trafficking and controlled substance, first degree fentanyl, Class B felony, 10 to 20 years. To trafficking and a controlled substance, first degree fentanyl, which is a Class C felony, 5 to 10 years. And then upon a plea of guilty of trafficking and controlled substance, first degree fentanyl, the defendant shall receive a sentence of 5 years to serve at 50%. The defendant shall receive credit for time served. The Commonwealth opposes probation and shock probation. The defendant,
I'm not gonna do that. Okay. It's fentanyl. I'm not gonna do that.
Okay.
So,
Thank you.
schedule trial. You have your calendar with you?
I do. We've also got a suppression motion that we would file. We would have to have that heard first
That'd be good.
before we could do a
You
trial.
always got it right, but I'm gonna schedule a trial and because it'll be something you can do the suppression motion next month, okay? Okay, it's
We can't set a trial. Because we've got motions pending.
That's what
we're gonna let him do the motions next month
Oh, okay.
and then we'll just,
We'll have to
Reserve.
make sure the last people's available.
okay, well, we just
Set
schedule.
it and we'll.
What kind of bond is he on? You know, I'm at this time in my life, I'm really raw about fentanyl. And I just can't dismiss, I'll let a jury decide what they're gonna do about fentanyl.
If I may, Your Honor, I mean, this is a very young man.
Well, a jury will decide that, and then I'll take a look at it after that, and I'm probably.
Sometimes the court would
Well, I'm
have,
not want to talk about this
All
right
right.
now. It's
Yes,
not the
sir.
time to talk about it.
All right.
Okay, we'll talk about that sometime.
November 13th.
You schedule motions on, any motions you have on the
I'll
13th.
let you know.
Yeah, y'all can just by agreement discuss.
All right, good. Thank you.
You want, hold on a second. You want-
Is that here?
Yeah. And if y'all want to take a look, if y'all want to take a look at a longer sentence on the aggravating situation at the low end of that, low end of it would be 10 years, correct?
At 85%.
Well, or, you know,
That's fine, Judge. We'll discuss it.
okay.
November 13th is the next date. Is that correct, Judge?
Yeah, that's correct.
Thank you, Judge.
Yeah. They don't want to set a trial yet. They want to do the
Well, I mean,
motions.
I wouldn't mind, but we.
You know, we'll just have the motions in. We got
That
plenty.
one's a novel motion about the way the lab counted the grams. They're doing some kind of sampling method that I don't fully understand.
Yeah.
Yeah.
Okay, well, we'll hear it then. And we got some trial dates that'll remain open in that sort of situation. Grady Jones arraignment.
Bless you.
Thank you.
Are you Grady Jones?
Yes, sir.
Good morning. This is 25 CR 0055. Were you born in 1960?
Yes, sir.
Last four digits, social security number 9041.
That's correct.
Are you have an attorney?
Yes,
Who is your attorney?
parent from district court.
He was appointed down in district.
I'll continue that appointment. You here with purpose of arraignment. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance in the first degree and possession of drug paraphernalia, trafficking controlled substance in the first degree, and being a persistent felony offender. You understand what those charges are?
Yes, sir.
You acknowledge the identity, client received the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions. Is that correct?
That is correct.
Okay. We set a negotiation day on the 7th and the next court appearance on the 13th. I'm signing a reciprocal discovery order, sir, that will require the Commonwealth to give you the evidence they have to help you prepare for your defense. So November 7th and November 13th are both conditions of your bond, okay? Thank you very much. Danny Sheffield. Danny Sheffield.
We had produced evidence to the Commonwealth that he is in the hospital now. I believe he's had a heart attack and I don't know what his other issues are.
You don't have a rash of bad health incidents for
Well, I know
defendants.
last month, Mr. Hunley saw him and talked about how bad his legs were.
Yeah, I remember that.
Yeah, so I guess he probably, based on the medical
Okay,
record.
you want to just, you want to redocket it or you want to put on it? We'll go
Set
ahead.
it for December, and then if there's a problem, Mr. Bell will get in touch.
December the 15th. The negotiation day in December would be what?
We've already got it plead.
Oh, you do?
Yeah.
Okay.
Had it for like a month, he just.
Well, you don't want to negotiate again. They might back off of it.
He might.
Okay. Okay, Kristen Williams. Commonwealth versus Kristen Williams, 25 CR 0046. Are you Kristen Williams?
Yes, sir.
You born in 1989,
Yes,
last
sir.
four digits, social security number 7658.
Yes,
You're here
sir.
for the purpose of arraignment. You have an attorney? Do you have one in district court? I'll
Yes.
continue that appointment. The grand jury of Monroe County's returning indictment charging you with traffic and controlled substance in first degree first offense. You understand what that charge is?
Yes, sir.
Counselor, do you acknowledge the identity of your client received the indictment, waive formal reading and arraignment, entered not guilty plea, reserving all pretrial motions?
Yes, Your Honor.
You sign a reciprocal discovery order, which requires the Commonwealth to give you the information they have to help you prepare for your defense. You have a negotiation day on November 7th. Is it 9 a.m.?
It is.
9 a.m. on November 7th. You'll be there and here on November 13th, and both of them are conditions of your bond, okay? Carrie Williams. Carrie Williams. Commonwealth versus Carrie Williams, 25 CR 0047.
Morning, Judge.
Morning. Are you Carrie Williams? Were you born in 1991? The last four digits social security number 0020. You're here for pretrial conference. What do we have?
We have an agreement, Your Honor.
Is it a felony plea or
It's pretrial diversion.
pretrial diversion? Now, you're soft spoken. You're gonna have to speak up a little bit because that's a voice activated microphone. So we'll get you on the camera. A motion's been tendered, says you wish to enter a guilty plea. Is that correct?
Yes. Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0047?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these matters with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You understand that you have certain rights under the Kentucky United States Constitution. Before I can take your plea, I need to know you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to have a speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event I don't accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, I'm going to ask you some qualifying questions.
Okay.
Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you on probation?
No, sir.
You understand if you fully complete the diversion program, the charges will be dismissed, pre-trial diverted, and you can have your record expunged. Do you understand that?
Yes.
You understand that if you do not fully complete the diversion program, you will be brought back before the court, and the court will schedule a sentencing hearing. You understand that?
Yes.
Who's the, Mr. Judd, do you have the Commonwealth's recommendation? If you'll step to the left there, young lady, okay?
The Commonwealth agrees to dismiss careless driving, which is a violation. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years pretrial diverted for 5 years supervised. The defendant shall receive credit for time served. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant agrees to have any and all evidence above case forfeited and destroyed in a manner that is consistent with the laws of Commonwealth and the holding agency.
Is that your understanding of Commonwealth's recommendation?
Yes, sir.
Has anyone offered you any recommendation or benefit for the plea? Are you entering the plea because you did commit the acts charged in the indictment as
Yes,
amended?
sir.
Doing so of your own free will.
Yes, sir.
Knowing your constitutional rights explains still your desire to have these rights, you waive these rights and allow me to fix the punishment within a range permitted by law. Is that correct? Is that your signature on the offer and the order?
Yes, sir.
I accept the agreement. Now, is she gonna, was there a drug court thing
No,
involved?
it's SSC, Your Honor.
Okay, so you don't need to meet with the probation, what are the court costs? What are the court costs? How much? $265. Okay. Okay, you'll need some time to pay that, I'm sure, right? So you start paying 30 days from today, you pay $30 a month. You pay, and you need to meet with probation and parole officer. Okay, thank you very much.
Thank you, Your Honor.
Yeah. Jason York. Jason York. Commonwealth versus Jason York, 25 CR 0040. Are you Jason York?
Yes, sir.
Good morning. Were you born in 1974?
Yes, sir.
That's 4 digit social security number 1433.
Yes, sir.
You're here on 25 CR 0040 and 25 CR 0041 for pretrial conference. Do you have
Yes, sir.
pleas ready in these cases?
Yes, Your Honor.
Are they felony pleas or diversion?
Felony, you know.
Felony, okay. I've just been informed that you have filed a motion that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the two indictments, 0040 and 0041?
Yes, sir.
Was your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
You viewed the evidence the Commonwealth has against you.
Yes, sir.
You believe in fully informed about this case.
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution.
Yes,
Before I
sir.
can take a guilty plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. You have a right to use evidence, right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and you have a right to apply the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering this plea, you give up those rights. You understand that?
Yes, sir.
I may consider this Commonwealth's recommendation and may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation, and decide to impose a harsher sentence, you have the right to withdraw your plea. You'll step to your left, please. Mr. Stockton, your
Yes.
recommendation.
Your Honor, Mr. York will plead guilty in 25 CR 40 to trafficking in a controlled substance first degree, receive a sentence of 3.5 years. In 25 CR 41, he'll plead to trafficking in controlled substance first degree, receive a sentence of 3.5 years. Those two sentences shall run consecutively for a total of 7 years. He'll serve 180 days on home incarceration with the balance probated for 5 years, supervised. He'll be referred to the SSC and follow all recommendations.
Is that what you agreed to?
Yes.
Wasn't any fentanyl involved in this?
There was, there's methamphetamine, and the reason I agreed to home incarceration is these cases are over 4 years old. So hopefully he got his life straightened up.
If I ordered a P test today, would you pass it?
Yes, sir.
I'm gonna take your word for that. Okay.
May I take it?
Is that was your understanding of the recommendation of Commonwealth?
Yes, sir.
Are you pleading guilty to the acts charged in the indictment because you did commit those acts?
Yes, sir.
Well, your constitutional rights is still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment.
Yes, sir.
You understand that after entering a guilty plea, any future conviction could be enhanced under this plea under persistent felony offender law. You understand that?
Yes, sir.
Okay, I'm going to, is that your signature on the docket? I'll
Yes, sir.
accept the plea, order pre-sentence investigation report, have sentencing on November the 13th. Now, is there any in-person individual here, probation parole officer right over here? Is there anyone else here that's on the in-person docket rather? Is Christian County on the line? Christian County,
Mr. Davis had spoken to him this morning and they were gonna try to get on, but they had a bunch of other court appearances, so they weren't sure what time he would be on, but I think he was gonna pass the test anyways.
And Your Honor, Lee Davis for Steve Brown, who I think is the only person at Christian County.
yeah,
I've talked to him this morning. I'll waive his appearance. We're still trying to get some records from the task force and the hospital.
what does the Commonwealth have to say about it? What kind of records you want?
I knew he was trying to get records from the hospital. I don't mind passing it one more month, but I think we need to resolve it after
And-
that.
Okay, and let's do a transport order on it.
Yes, sir.
Do it on November 13th, we do a transport order.
Yes, sir.
Adair County, are you on the line?
Thank you, Your Honor. May I be excused, sir?
Absolutely.
Thank you.
Adair County, is Adair County on the line?
Your Honor, this is another motion for release of DCBS, but So if his council will agree, we won't have to have it.
And Judge, no objection to that. I'm just making my first appearance for Mr. Tabor, I think.
Tabor, yeah, Silas Tabor.
Yeah, sure.
Okay, well, you have your information to give to the clerk as far as your entry of appearance.
I can do that, Your Honor.
Okay. Madam Clerk, he's making an entry of appearance, so he'll give you the address information, or things. You just step over and do that. We'll go, yeah.
Matthew Profit's here, he's made volunteers on the Barron County.
Okay, we'll get him to the next.
Do we-
And then we also had
State.
Ms. Burkwell on the output. We've had
Work right here.
the AOI done. The very first one.
Yeah, I got Birdwell coming down there.
She's here. We just did the AOI.
I'll do that AOI. I got her paperwork.
We just passed over because she had another pretrial.
Yeah,
That's fine.
I made a mistake on that. You're down to Barron County Jail, okay? Oh,
We need a date, 13th and the 7th for negotiations.
7th for negotiation and the 13th. Yeah, and I guess your client needs to be transported. Where is the client?
He's in the Dyer County Jail. If he wants to press it, then we do a transfer.
You'll need to do a transport.
I can do
order for
that,
Both of those days, 9 a.m. for both those days, okay?
Okay, thank you,
Okay.
Judge.
If it makes bond between then and now, those are conditions of bond, okay?
Understood, Your
Okay,
Honor.
thank you very much. Ricky Birdwell. Was she eligible for the public defender? Okay, I'll sign an order appointing a public defender. Commonwealth versus Ricky Birdwell. 25 CR. I'm gonna have, do you have somebody here to test her?
Ms. Vanderpool, I guess, can help.
Yeah, I'm gonna have her tested out. She doesn't look right to me here. Anything you need to tell me before I have you tested?
I'm in a lot of pain.
Well, that won't, the pain won't show up on the thing. Just test her and we'll see what's going on here. We'll come back to her in a minute.
That was Mark Brown, but.
Do what?
It was Mark Brown that should have been.
Yeah, Mark Brown. Okay.
Right under.
Yeah, I got it. Okay. You'll go with the detective there.
I don't know.
Okay, Ricky Birdwell's the only one we have left.
Yeah.
Mark Brown is in custody.
Matthew.
And then we have, Matthew Prophet. You want to come around? Commonwealth versus Matthew Prophet, 25 CR 0052. Are you Matthew Prophet?
Yes, sir.
You born in 2000?
Yes, sir.
Last four digits, social security number 4535. Do you have an attorney?
Oh, Kevin Parent.
Well, I'll go ahead and continue that appointment. You're here for the purpose of arraignment. The grand jury of Monroe County has charged you with operating a motor vehicle under the influence of alcohol or some other substance, fleeing and evading, failure to maintain insurance, and speeding. You understand those charges?
Yes, sir.
Counselor, you acknowledge the identity of your client, received indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
You have your client here on November 7th for negotiations, and November 13th is the next court date, okay?
Yes, sir.
Thank you very much. Continue on the same bond.
I got to take the need to fill out today. But I didn't know because you didn't make mine last night, so it's downstairs. Can you come back like after?
Okay, let's go on for Barron County Detention Center. Christopher Burks. Commonwealth versus Christopher Burks.
They are coming up the hallway with them right now, Your Honor.
Pardon?
They are coming up the hallway with them right now.
you'll step away from the microphone a little bit, you're blurring, and tell me what you just said.
I'm sorry, sir. They are coming up the hallway with them right now.
Okay. The other gentleman on here, is this Adair County? What's your name, sir? Yeah. Somebody didn't have a microphone on there.
Sorry, Judge, I got it, Judge. Sorry about that. Silas Tabor for you, Adair County Judge.
You're in Adair County?
Yes, sir. Smitty, I need the charger for this.
Silas
Smitty, I need
Tabor,
the charger.
we've already handled that. It was just for release of documents, wasn't it?
It's correct.
And scheduling for a pre-trial.
Okay, Mr. Tabor, your attorney was here a little earlier. And the only thing we did was sign a motion for release of documents and set you up for a negotiation day on November 7th. And then your next court appearance will be on November 13th. And your attorney will come over and meet with you soon to discuss that, okay?
Okay.
Okay, thank you, Adair County.
Yes, sir. No problem, Judge.
Okay, thank you. Y'all are excused. Who do we have in the room there in Barron County? We'll go ahead and see who we have. One of you guys want to come on up?
Can you see me, Your Honor?
Anybody from Barron County, bring one of them up there.
This is Mark Brown.
What's your name, sir?
Mark Brown.
He was there. Yeah, there he is. There he is. Mr. Brown, you're here on 21 CR 0034. Is your year of birth 1975?
Yes.
Last four digits, Social Security number 3114.
Yes.
Okay, we're here on a probation revocation. Mr. Barton, are you involved in this case? Okay.
I am, Your Honor.
He's going to testify. Okay, you want to stipulate?
I knew he had a
Speak
warrant.
up.
Yes, sir. I knew he had a warrant. I wasn't aware that he had been picked up, so I'm asking if we could push this to the November date, because I've not been able to speak with him.
Well, that seems reasonable.
It picked up last night.
So you just picked up last night and you haven't had time to discuss this with your attorney. It'd only be fair to continue this to November 13th.
Thank you, Your Honor.
And the officer can be released. Thank you very much, Mr. Barton.
Thank you, Your Honor.
Christopher Burks.
Are we released?
I'm going versus Christopher Burks,
Yeah.
25 CR. Christopher Burks,
Yes.
for the purpose of arraignment. Were you born in 1994?
Yes.
Last four digits of Social Security number 8386.
Yes.
Who is your attorney?
I don't have one. This is my first appearance.
You didn't go through district court?
Just an indictment, straight indictment.
Do what?
He has to be one step condition.
Okay, you've previously been qualified for the public advocacies. I'm gonna continue that appointment, subject to a form. So have him do a form, make sure we have one on file. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with failure to maintain insurance on a motor vehicle, fleeing or evading the police in the first degree, reckless driving, failure to signal, no rear view mirror in place, disregarding the stop sign, failure to illuminate a registration plate, speeding, and being a persistent felony offender on the fleet. You understand what those charges are?
Yes.
Yeah. You acknowledge the identity client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Scheduled for November 7th for negotiation day at 9 a.m. and November 13th for the next pretrial. Your attorney will be able to talk to you, okay?
Can we do a bond,
Your attorney will be over to talk to you. Okay, thank you. Stephen Coots. Stephen Coots.
Yes, sir.
Commonwealth versus Stephen Coots, 24 CR 0042. Are you Stephen Coots?
Yes, sir.
Born in 1990.
Yes, sir.
Last four digits, Social Security number 2446.
Yes, sir.
Purpose of arraignment, you have a right to remain silent. Who did your attorney?
Oh, I don't remember. This case is from 4 years ago.
Yeah. Well, I'm gonna go ahead and appoint the public advocate's office subject for the arraignment, subject you filling out a form as to whether you're eligible or not for public defender, okay?
Okay.
So you have a right. The grand jury of Monroe County's returned an indictment charging you with possession of drug paraphernalia and possession of controlled substance first degree. And giving a peace officer a false identifier. Counselor, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
November 7th for negotiation date and November 13th. And your attorney will be over to talk to you about any bond situation or explain what's going on to you, okay?
Sir.
Thank you. Commonwealth versus Herschel Hammer. Commonwealth versus Herschel Hammer, 23 CR 0083 and 24 CR 0025. Who represents?
Mr. Bale.
This is shock probation revocation. Give us what the deal is here.
Your Honor, Mr. Hammer has 15 years from two separate cases. He had multiple felonies, theft of firearm, wanton endangerment, first fleeing, invading, theft. He was granted probation. He was revoked. Then he was granted shock probation. And I've got Mr. Collins here to testify on that.
Let's just go ahead and take some testimony on it.
Yes.
You want to raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Please proceed.
Mr. Collins, Mr. Hammer was granted shock probation. When did you meet with him when he was released from shock probation?
He was granted shock probation on 4/4, and I met with him, shortly after that, as soon as he was released.
4/25.
Yes, correct.
Okay. Now, what happened? Did you have any violations after you were granted shock probation?
Yes, on 4/23, Mr. Hammer was drug tested and was positive for methamphetamine. We lodged him in the Barron County Jail at that time and got him assessed for long-term treatment.
Okay. And, what happened as far as the long-term treatment?
On 5/1, Mr. Hammer was released from the Barron County Detention Center, to attend long-term treatment center at the Healing Place for Men in Louisville. He was released to his sister Destiny. Spoke with him later that day. She stated they got halfway to the rehab and stated that she stated he was not going to go to rehab. He then called another rehab in Bowling Green, Journey Pure. She stated that he was wanting to go there. She also stated that he stated that nothing was going to happen to him if he got into another rehab. Then she stated she dropped him off at the hospital in Bowling Green, and he stated he was not going to rehab until the next day on 5/2.
Okay. Did you check with Journey Pure and try to find Mr. Hammer?
I do not recall that.
Okay. Did you realize that he never made it to the Healing Place?
Correct.
Okay. Did you ask for an arrest warrant?
We did. That on 5/1, an absconding warrant was issued.
Okay. Now, when was Mr. Hammer next heard from when he was picked up?
On 6/12/25, Mr. Hammer was arrested in Metcalfe County and charged 25F21 for the following: disregarding a stop sign, fleeing or evading a police first-degree motor vehicle, fleeing or evading police first-degree on foot, operating a motor vehicle under the influence of alcohol first, wanton endangerment second-degree police officer, wanton endangerment second-degree, and no operator's a moped license.
Now, those charges are still pending. Is that correct?
Correct, to my knowledge.
Okay. And just for background, when Mr. Hammer was initially probated in this case, how long was he on probation?
So he was granted probation on 8/15/24. And an absconding warrant was issued that time on 10/22/24.
So basically about 2 months.
Correct.
Before you abscond. I had nothing further here.
Would you like to inquire?
I would, Judge, thanks. The charges you mentioned in Metcalfe County at this time, you don't know a whole lot of the facts as far as the nuances of the law and what he'll be convicted of and what he's not. Will that be?
I do not.
Now, as a probation and parole officer, do you, in essence, know all the history of the people that you supervise and have to adapt maybe what you're doing to supervise that person and give them the right opportunities to be successful?
We do that in a sense, yeah.
And with Mr. Hammer, do you know how old he is?
He's young.
He's 19 years old,
Yes,
is that correct?
That's correct.
When all this was going on? And when he's being sent to the healing place in Louisville, correct?
Correct.
And I believe they called, and correct me if I'm wrong, and stated that he was very afraid, scared to go up Louisville, didn't want to go to Louisville, wanted to go to a different facility. Asked if any arrangements could be made.
I don't remember that. It very well could be.
So it's a possibility.
It's a possibility.
Yes.
Yeah.
And have you had interaction with the rehabilitative centers in Louisville?
Very minimal.
Those that you have, do you understand that they don't have a great reputation, especially for people in rural areas?
I'm going to object to this line of question. The issue is not we don't have the rehabs in Louisville on trial. We've got Mr. Hammer's actions. If he didn't like the rehab in Louisville, he could have turned himself back into Mr. Collins. I don't think that's the issue.
I agree with that. I don't think it's relevant.
We're just,
I don't agree. I don't think it's relevant. He's got these other charges over in Metcalfe County that concern me more than him not being compliant with the orders and wanting to have a choice on which rehabs he goes to.
I'll move on, Judge.
Yeah.
Do you know, about Mr. Herschel Hammer's background as far as your ability to supervise him and make decisions?
I'm gonna take this case under advisement to see what happens with the Metcalfe County cases.
That's fine.
You know, I'm convinced there's enough to revoke him right now, but I just think it would be in everybody's best interest, including the defendant's best interest, to roll this all into one thing if he gets, enters a plea over there. And if he's found not guilty over there, then we can pick this up where we are now and take a look at this case here.
If the charges were reduced dramatically.
I'm not gonna like, you know, I want to see if he's violated the terms of his probation.
Judge, I would like to get in to the court, this young man's history, which I think would be relevant with probation and parole and the court's decision. Because I feel like, Judge, and it's just my opinion, but some people in this world deserve more chances than others. Because when I grew
The
up,
ones that you represent deserve more chances than others. I was that way when I was defense attorney too, but you know, I understand that he's young. I'll look at his
and
precincts
he's
of
had
this.
a terrible childhood, Judge.
Yeah.
Not had a lot of opportunity.
And he's also not compliant with court orders.
Yes, sir.
You know, and he signed these agreements that he was gonna do that and it was gone over with him and he hadn't done any of them,
But
but
at 19.
well, I understand that and we'll have an opportunity. I told you, if I want to see how these things in Metcalfe County go, and depending on how they go, then I'll give you another bite at the apple. I'm not going to just enter an order. We'll come back here and Lord willing, we'll have the same probation, parole officer, the same prosecutor, judge and defense lawyer, and we'll take a look at it then.
That's better than being revoked, Judge. So
It is
appreciate
better.
that.
So you, small victory is better than a complete defeat. Isn't
That's
it?
right.
Okay.
Thank you.
Okay. Thank you very much. Your attorney will be over to talk to you, sir. What, did y'all do a test? What's the deal here?
She's been able or unable to provide a sample, but however, she has admitted to marijuana and possibly meth being in her system.
Yeah, well, she's in custody. Yeah, we'll go ahead and we'll do the arraignment here. Let's go ahead and do the arraignment. Give me the arraignment papers. Wait just a second. Wait just a second. It's the grand jury of Monroe County's returning an indictment charging you with traffic controlled substance, first degree, first offense, drug paraphernalia, possession of marijuana, and possession of controlled substance, the first degree methamphetamine. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions, schedule it for the 7th and 13th. Now to the jail staff over here. I would suggest to the jail staff, y'all listen to me, jail staff. I would suggest that you have her medically cleared before you try to take her over there. I don't know whether you do it here or do they do it over there? Which way you do it? Yeah, I would suggest that, because I had her screened because she doesn't look like, I think she's coherent enough to be arraigned, but she got something going on and she's admitted to meth and marijuana and we don't know what else, okay? Thank y'all very much.
270 819 9789.
Haley Hill. Haley Hill. Good morning. Are you Kaylee Hill?
Yes.
25 CR 0054. Are you here for the purpose of arraignment?
Yes.
Mr. Garrett, is this your client?
It is, Your Honor.
Y'all are keying the microphone over there. Thank you. Ms. Hill, were you born in 2000?
Yes.
Last four digits, social security number 0368. You're here for the purpose of arraignment. You have the right to be silent. Your attorney is on the line there. He's not present today because of a medical excuse. The grand jury of Monroe County has charged you with assault, 3rd-degree, 3 counts, operating a motor vehicle under the influence, resisting arrest, disorderly conduct, the 2nd degree, and menacing. You understand those charges? You understand those charges? Mr. Garrett, do you have a copy of the indictment?
I don't judge, but that I will waive that.
Well, we'll send it to you. I guess we have to email it, or they have your fax number and fax it to your office.
Yes, Judge.
Okay, you acknowledge the identity of your client, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, we'll set you for November the 7th for a negotiation day, November 13th. I'm assigning a reciprocal discovery order that the Commonwealth has to sign. The Commonwealth, I'm signing, the Commonwealth have to give your attorney information to help you prepare for your case. And
Judge,
he'll talk to you about your bond situation things, okay?
Judge, there's also a motion to revoke, so if we
Else
can
on the
just,
docket? You have anything else on the docket?
it's a motion to revoke. If we can just pass that as well.
Yeah, we'll either get it resolved on the 7th or get a trial date on the 13th.
Okay, that'll be fine.
Judge, thank you for letting me appear by video. I'm outside the foot doctor now.
Okay, take it easily.
Thank you.
Dustin Jesse. Hold the sheen. Hold the sheen. Yes. Dustin Jesse. Commonwealth versus Dustin Jesse. 24 CR 0099.
Yes, Your Honor, that's Commonwealth's motion to revoke probation. Mr. Jesse has a 6-year sentence, tampering physical evidence and a PFO second. He had an EPO or DVO issued against him, I believe, in Allen County, and he's had 2 misdemeanor convictions subsequent to that where he's violated that EPO, DVO.
What do you have to say?
Your Honor, we're asking for a hearing at this time.
Sure.
I call the probation officer, Mr. Bray.
Mr. Brady, raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
State your name.
Officer Wesley Bray.
You can lower your hand there. Who do you work for?
I work for Probation Pro in the Glasgow office.
Okay, go ahead, Mr. Stockton.
Mr. Bray, have you been supervising Mr. Jesse, or did you just recently get this case?
I got this case on July the 29th this year.
Okay. Have you reviewed the probation violation report?
I have.
Okay. And does Mr. Jesse have a EPO, DVO pending against him in Allen?
Does.
Okay. And that involved a lady named Julia Oliver, I believe. Is that correct?
Yes, sir.
Okay. Subsequent to that EPO, DVO being issued in July, I believe it's the July, has he had any violations of that EPO, DVO?
Yes, he had two different cases that he's been convicted of for violation of EPO, DBO. Those are Allen County 25M 249 and Allen County 25M 259. And he was sentenced on both of those on July the 16th of this year. And he was sentenced to jail 60 days, 47 days conditional, credit for 13 days, and no further violations of law on each one of them.
Okay. And did these cases involve Mr. Jesse attempting to contact Miss Oliver?
Yes.
Okay. I have no further questions.
Your Honor, may I proceed?
Please.
Officer Bray, you stated you've only been supervising Mr. Jesse since I believe July of this year.
Yes, July 29th.
Is that because he was in a long-term treatment program prior to that?
I believe so.
Okay. And are you aware of whether or not he had graduated the program?
I think he has. I would have to look back on his paperwork. I think it does say that he graduated some of it.
Okay. And other than the violations that we're here for today, are you aware of any other violations of Mr. Jesse's supervision?
Not at this time, no.
And he actually entered onto supervision, I believe, in January of this year, correct?
January 17th, I believe.
And so these are the first violations that have been filed against him.
I believe so. Yes, all of these are all dealing with the same female and EPO violations, yes.
Okay. Those EPO violations that he has pled to, have you read the citations for those?
I have.
Were there any allegations that he had made any threatening or sent any threatening messages or threatened any acts of violence in the messages themselves?
Yes, according to the reason the petitioner on the first DBO that she said that he had thrown a Sprite can at her, he's burning with a cigarette. He has threatened to kill him, kill her, drove 100 mile an hour with her in the car.
Officer Bray, just
out the window.
to clarify, those are the allegations that were in the
Those are allegations he was convicted on, yes.
On the EPO or on the EPO violations?
On the EPO violation, yes.
I don't know if I could just a second. So Officer Bray, I'm looking at the violation report that was filed. It looks like he has been convicted in two separate cases involving EPO violations, correct?
Yes.
In the first one, it states that the violation was based upon a letter that was sent that said something along the lines of, please drop this, you're my life, Julia.
That's correct.
Okay, so that is not in any way him threatening violence, correct?
No, that's the first one. The second one he does, but the first one he doesn't.
Okay, I have no further questions. Thank you.
I have no reason.
You want to call any witnesses?
No, Your Honor, not this time.
Your Honor, I would say.
That Mr. Jesse was probated. This lady got an EPO out against him. Whether it happened in the EPO or the subsequent misdemeanor, he hit her, burned her with a cigarette, according to her, threatened to kill her. And then he had subsequent violations where he was attempting to contact her. And one of those contacts was, he says, you need to drop this because you're my life. Which is a felony in and of itself.
The original felony is what?
The original felony is tampering with physical evidence and PFO. Mr. Jesse is the person that had all the methamphetamine on his person, overdosed here and had to be taken to the hospital.
Well, I'm asking that his probation be revoked.
Your Honor, what I can say at this point in time is that the allegations of domestic violence that were made in the EPO, I would point out that the issuance of an EPO is a civil order, with a lower standard than what is required for a criminal conviction in court. And therefore, he has not been convicted of any violent acts against Julia at this time.
Well, there's a court finding that they happened, though.
Your Honor, there's a court finding for the purposes of the issuance
But
of a
that they
civil
happen.
protective order. It is a lower standard.
I
It is not
understand
proof
what the
beyond a
standards
reasonable
are,
doubt.
but there is a finding that these things happened, which make them stronger than a mere allegation.
Well, Your Honor, what I'm asking at this
Would you
time,
acknowledge that, make it stronger than just a mere allegation?
Your Honor, I would say it is stronger than an allegation, but it
Okay,
is
well, that's
not the
good.
same standard.
Yeah, I understand the standard.
What we are asking at this time, Your Honor, because these are Mr. Jesse's first violations after being on supervision successfully for almost a year at this point. He did complete.
I noticed you didn't ask him any questions about what the second one was. I didn't have that in front of me. What was?
I don't think it's in the report. We've got one of the
You got
citation
it.
reports.
Would you read the second one to me there?
Your Honor, I don't have the actual police report for the second one.
There was a conviction though, wasn't there?
There was a conviction.
What was it? What was the stated reason for the conviction? Probation parole officer, I'll ask you, what, on the second one, what was?
Do you want me to read the body of the allegation, Judge?
On the second one, yeah.
Yes.
Okay.
I'll read it to you. Petitioner says that on during 6/22/25 through 7/1/2025 in Allen County, Kentucky, the above named respondent engaged in acts taken against a household pet as a means of coercion, control, punishment, intimidation, or revenge. I am here seeking protection due to Mr. Jesse threatening to hit me and almost throwing a Sprite can at me. He has burnt me with a cigarette. He has grabbed me and left bruises all over me. He has threatened to tear everything up between my house and Marion County if I leave him. He has stolen my car keys, removed fuses from my car so I can't leave with my 3-year-old daughter. He has threatened to kill me if I leave him. He has drove 100 miles per hour down the road trying to kill me in the last 2 hours and threw my phone out the window so I can't call for help. I am truly scared of him at this point. I do not feel safe or feel that my children are safe around Mr. Jesse. Thank you.
Your Honor, if I can just point out one thing, in the violation report, it says clearly that what was just read is the complaint or the petition that was filed for the issuance of the protective order. It is not the citation for the second criminal case for EPO violation.
I think Ms. Hill's correct on that.
Okay, well, what was the complaint on the second violation?
Have that, Your Honor, that's what I'm saying.
What was the complaint on the violation?
Brady's got it.
Not the original petition for a protective order. I'm not talking, what was the second violation? Officer?
Allen County 25.
I didn't get that. I just got the part where he was convicted.
Do what?
I don't have that information. I'd have to get that. It was just where he's convicted.
Yeah,
We might be able to pull the citation up on court now.
let's do that.
We may, I don't know if we can or not.
Was the original petition for a protective order, EPO, DVO, was that prior to his plea here?
No, it was after he returned from long-term treatment.
Yeah,
And
you
it just
didn't-
happened this past July.
yeah. So there wasn't a request to revoke him on that.
I've got it, Judge.
No, we.
What do you have? We've got up here. Go ahead.
Okay, violation of Kentucky EPO DDO on 7/5/25 at approximately 22:10 hours. Julia Oliver arrived at the Allen County Sheriff's Office to report that her husband Dustin Jesse was contacted from the Allen County Detention Center. Jesse was served with EPO on 7/4/25, where Julia Oliver is the petitioner. Jesse was taken into custody on the same day and charged with violating the EPO. Julia Oliver showed text messages she received. The first message read, "I love you, I'm sorry." She replied, "Who is this?" The second message read, "You know who it is." I reviewed the chirp messages that were sent from the Allen County Detention Center. The messages came from inmate Jacob Pecker. According to the records, Jacob Pecker and Dustin Jesse are in the same cell at the Allen County Detention Center. Pecker and Jesse were both interviewed separately and each read the Miranda rights before questioning. Jesse denied any involvement with the messages sent from Pecker's chirp account. Pecker stated Jesse never used his chirp devices in messages. On 7/9/25, I made contact with Josh Anderson, who works at the Allen County Detention Center. The messages that were sent to Julia had a timestamp of 21:47 on July 5th, 2025. I asked Anderson to pull the camera footage from that cell near the time. There is no audio of that footage. The camera footage, I observed Jacob Pecor near his bunk standing in the adjacent bunk. Dustin Jesse is laying on the top bunk. At the timestamp of 21:44, I observed Pecor remove his chirp device from under his pillow and use the device. Pecor then turns the church screen towards Jesse. Jesse then begins speaking to Pecor as Pecor begins using the device again at approximately the same time that Julia began receiving the messages according to the timestamp. I asked Anderson if the timestamp was correct, and he stated that they could be off by up to 5 minutes. Later messages, according to the records, state that Pecor had messaged Julia as a mistake due to a wrong number after Julia stated she was going to call the sheriff's office. I contacted Julia Oliver and asked if she knew Jacob Pecor. She said she did not. Dustin Jesse violated the EPO by using Pecor as a third party to send messages to Julia.
Okay.
Your Honor, that was one of the convictions, and the other conviction, when he was in jail, he was trying to get his mother in contact.
Yeah. Well, now let me go back and ask one question again. The original DVO that was entered, was that petition for the EPO and converted DVO, was that subsequent to his plea that put him on probation here?
Yes. Yeah, he was.
Well, and that in and of itself then should be considered on for revocation purposes. Do you agree?
Yes, I was just looking to see what day the plea was. It was back last year.
Yeah.
Your Honor, I do disagree. It is a civil finding, a civil order. It is not a criminal charge or conviction to have an EPO or DVO issued against you.
He was sentenced on January the 16th of 2025 is when he was sentenced. And this is the thing that bothers me about this case. It's two things in my legal career I've never been able to understand, is why a woman would stay with a man that continually beats her, and why a man would continually harass a woman when she doesn't want anything to do with him. And people like Mr. Jesse are dangerous because women are killed in cases like this.
I understand why they stay with him.
Yeah.
Because they're afraid of him.
They're afraid of it. Yeah.
That's why they stay with him.
But that's the two things that's bothering me.
Now, let's pull out the conditions of his probation and parole and see what sort of actions would violate him. The counsel here says that burning someone with a cigarette and doing all these things is not violate, that an EPO or DVO do not violate what you're saying.
Because it is a civil order.
I understand what it is. You're saying that an EPO or a DVO will not violate somebody.
I do
Is
not
that what
believe,
you're saying?
I do not believe it is a violation.
Okay.
Mr. Bray, is there any conditions there that he should not have any violations of the law? Because he had 2 misdemeanor convictions.
Yes, he's not supposed to be arrested. He's not supposed to, it's part of his general conditions. He's not supposed to have any new arrests or that, let alone convictions, but not even arrests. So.
He had 2 convictions.
What were they for? For violation? How about the convictions for criminal convictions for violations?
Your Honor, I cannot argue that the convictions are not in and of themselves
Okay,
violations.
well, then, if you don't have progress, I'm revoking his probation.
Your Honor, if I could at least just reiterate, these are his first violations. We would ask the court to give him the opportunity to be.
Well, let me
released.
tell you something. I do not, I take very seriously someone who does these, we have so many EPOs and DVOs that are weak. And we have to turn some of them down. But the original allegations in this were very troubling and severe. And this gentleman was on probation and he was told not to and he got convicted in pleas on this sort of thing. So no, but you made your record. Okay, thank you very much. Guy Williams. Guy Williams. Are you Guy Williams?
Yeah.
This is 25 CR 0016. You're here on a probation revocation. Were you pretrial diversion revocation? Were you here on, you were born in 2003? Is that correct?
Yeah.
And the last 4 digits social security number is 0258. It says that Johnny Bell is your attorney. Mr. Bell has left. He was here earlier.
He may have just been the attorney in the underlying case.
Well, I'm gonna appoint public advocacy. And let you fill out a form. Since y'all haven't, what are the accusations in this thing? And I'm not gonna take proof now because the attorney hadn't had an opportunity to interview his client, but what are the
He
allegations?
has a 3-year sentence on possession. He was supposed to complete substance abuse treatment. He went to the Mark Center in Bowling Green on September 14th, 2025. He was discharged on October the 3rd. And he didn't report to his probation and parole office, and they tried to contact him and couldn't find him.
Okay, well, we'll put this off until November the 13th.
Yes.
Okay, now is there anybody else that I haven't seen there?
We got, Nora Adams.
It's a drug court situation and it won't be for me, it'll be for Judge Costello. Okay. What would she be there?
She's on a sanction.
She's there on a sanction, so there's nothing else for me to.
Graves will be called.
Yeah, Mr. Graves will be over to talk about that. Do you have anybody else? If not, you be excused. Is there anybody else on the criminal docket? Okay, that includes the criminal docket. You bring the grand jury in.
These guys will take us ready to go back. Can we be excused, Your Honor?
Yeah, you're excused. Thank you so much for your cooperation.
Thank you. Have a good day, sir.
I'm not sure what's happening right now. And I've been litigating for over 5 years now. It's not like I'm brand new.
Yes, I think it's, yeah. Do you have a card?
Didn't bring it with.
Okay. I'll get your information.
Okay. Adair County, it's my own county, I can't seem to get work in.
I've got guardian ad litem.
And I talk to people and they're like, yeah, they really do gatekeep around here. You know, I didn't think it was a big issue because in Nashville, when I was trying to, you know, we welcome students. It's like, there's plenty of room at the bar. Come on, we'll help you out. It's not finding out where I live. What city is it, County of Blaine?
Columbia in here. They put in.
So those kinds of things, it just needs to be cleaned up.
Fancy art.
Hey, that's perfect.
Most people have arrived, I should see this sections here. Is there anyone here for Amy Page?
Not judges or what.
The other side didn't show up.
All rise. Monroe Circuit Court's now in session. Honorable Judge David Williams presiding. Please bow with me for a moment of silent prayer.
Thank you very much. Everybody be seated. Do the child support docket. Crawford versus Crawford.
Continue to December the 11th.
No, 15th.
No, December the
15th.
15th. Is that the correct date?
That is correct, Dave.
Yeah.
Mitchell Russell versus Ashley Curtis.
Continue to December 15th, please.
Fox versus Fox.
December the 15th, please.
When is that gonna be?
Likes a while.
Still a while?
Yeah.
How old are the
Still
children?
charging or is it
It's no back pay,
all arrears?
just
It
some
was
thousands.
$4,000 3 months ago, so.
I think he pays $50 a month.
Offered a deal on that one somewhere, you know, a discount, you know. Graves versus Graves.
Continue to December the 15th.
Stinson versus Graves.
That's our motion to intervene just so that we can start collecting child support. There's two of those.
Submitted electronically. Milam versus Graves.
Same thing, just an intervention.
Turner versus Guffey.
December the 15th, please. Nobody has to be sworn in.
Hested versus Hested.
December the 15th, please.
Is that the correct pronunciation of that after all these years? Or Taylor versus Houchins? I know how to say it.
December the 15th. And I was talking to Megan. Mhm.
Hudson versus Hudson.
December the 15th, please.
Jimenez versus Jimenez.
December the 15th, please.
Dye versus Jones.
December the 15th, please.
Jones versus Jones.
December the 15th.
Page versus Page.
December the 15th.
We're not doing much in November then, are we? Huh?
How will we go? That's when I go to
Oh,
Quantico, so
you know, Pennington versus Pennington.
December the 15th, please.
Rich versus Rich.
December the 15th, please.
Smith versus Smith.
December the 15th, please.
Starling versus Starling.
That is our motion to intervene, just to start.
Submitted electronically, that's all right. Let's go off the record just for a second. What's she?
Oh, jeez.
Yeah,
Thank you. See you, Jeff. She would. Have a good day.
okay, let's go, Clemens versus Clemens.
Your earliest.
What time is it supposed to be?
1:15, make sure the party.
Okay, let's wait another 10 minutes, go off the record again.
Judge, we can go ahead and do that one.
Oh, we can? Okay,
Yeah.
well, thank you. Go ahead.
Judge, this is my motion for an agreed status quo order.
Yeah, I saw that.
He just, other party justice, Mr. Driver just entered his appearance and we will be submitting an agreed order. I believe he may have tendered his entry of appearance this morning. So we've drafted it and I've just got to put his name to it and file it.
Okay,
So,
okay, well, electronically submit it and
Yes.
we'll take care of that.
yes,
Okay.
Judge, thank you.
Yeah, good job. Like agreements. Here, the lawyers here, we like agreements. Okay, the next one is Short versus Cook if the parties are here.
We are, Your Honor.
Okay,
Just on for a status conference, Your Honor.
yeah. Well, I tell you what, I'm inclined, this is where I have my inclination case here. I'm inclined from the evidence here, although I'm inclined to say that the contract is valid because of the signing of the consideration thing. I don't like it much, that it's for past services and things like that, but that's where I'm inclined. But I'm also inclined to rule that they have violated the terms of the lease. And so we'll need to have a hearing on what kind of damages or offsets that there might be in a thing. Now, does the lessee want to continue to occupy the property?
I'm not so sure that they do anymore.
Well, I know, so that we get into the thing. Now, does the lessor and her representative, do they want to terminate the lease?
They want to terminate and get their property back.
Well, I know that.
Yes,
But if I rule that the contract is valid and the termination is valid, then there would have to be, they would be entitled to offset some of that $30,000, or was it $30,000?
I believe that's
Yeah.
correct,
Yes, sir.
yes.
You know, I mean, we have to come to some accommodation on how much of that has been owed and whether or not they have to, whether the termination does away with any obligation to pay and, you know, that sort of thing. So knowing that I'm having a tendency to find that the contract is good but that there will be there could be some offsets as far as damage to the property, you know, that
Yes, sir.
sort of thing. I would suggest that you go back to the parties and see if they, knowing that, I'm ready to rule on it, except I don't have any information about damages or offsets or anything, because I don't think we have much proof about that, do we really?
They were still occupying the residence at that time, and my clients understood that it was damaged, but of course, we don't know what repairs will be needed or anything, so I know. there was no
So I think
testimony.
that there ought to be an order entered to let your clients, you know, go in and inspect the property and give you notice on what they're gonna claim as far as damages to the property. Because if we terminate the lease because of damages, then there would still be the situation of, what do we do with the amount? If it was rightfully terminated, it'd be your position. The thing about it is all this was done for previous work, but it was, I guess, going to be applied on a month by month basis. So your position would be that if they rightfully terminated the lease, then your clients would be entitled to a refund, right?
Yes, sir.
Yeah. And it's your position that they wouldn't be because it was for previous work and you don't think they violated, right?
Well, we don't feel like we violated the lease, but we feel like if the lease is canceled, that we're owed what the lease was valued at. Excuse me, valued at.
Well, that would have to do whether it was properly canceled or not. If it was properly canceled, you wouldn't be entitled to that. There's no refund because it was for previous work. I mean, I think the lease was valid, but I've never seen a lease like this where there was it was paid for by work previously done. Then there would be the situation where your clients were entitled to be compensated for the work that they had done if the lease is invalid. You follow what I'm saying?
Yes, sir.
So, I mean, that's the reason you hadn't had a, you know, I've kind of been wrestling it around and, you know, feel one way or the other. There's no way that there's going to be an agreement on this thing at all, you would think.
I don't know.
Well, I think the lease is valid. The lease is valid for prior consideration because there hadn't even been any proof to the contrary. Of course, the fact that they signed the thing that there's a cash receipt for it, you know, is not a good thing, but
But there was testimony that it was never paid.
it wasn't paid, but there's also testimony that the $30,000 was for work previously done. That's what they're saying.
Right.
I don't see that anybody would, I mean, I'm convinced that when she signed that agreement, that it was for work previously done from the testimony that I have now. I mean, I believe that to be the case. So y'all want to, you know, you had a bench trial on this thing, I guess, which was my mistake. Sorry. Should have let a jury just go ahead and let them lay where Jesus flings them. You know what I mean? So I have a tendency to believe that she wouldn't have signed that she paid the $30,000 unless it was, and of course she maintains it was just periodic things, going to the grocery. She bought their groceries, that sort of thing. I don't know. Some of the worst cases I've had when I was practicing with when people filed claims against the state for work they've done. I had one famous case over there that I was practicing my closing argument, said, I know how Miss Spears died. She was pampered to death because all these people had appeared and done all these services for her. So there's where I am right now. So what do you suggest? Let's say if I find that the lease was valid, you know, as far as it was, do you believe that y'all have violated the lease anyway, or?
We don't believe we violated it. As far as damages are concerned, you know, when my recollection is there was testimony that there was holes in the walls and that the septic didn't work when they moved in. So I don't know what kind of damages are claimed, but
Yeah. And what are you claiming they did? Of course, it was claimed that your client wouldn't let them on the property to fix the septic, right?
That his clients wouldn't let us
Yeah,
on the property.
that you had someone to go on to fix
Yes.
the, so that wouldn't be a violation for not doing, it's your opinion, you tried to fix the septic. We're going to, yeah.
Right. But we contend that septic was damaged after they moved in.
Yeah.
that it actually worked when they moved in, and that the
Well,
holes were
septics don't have to
created.
be damaged. I mean, septics go bad whether you use them appropriately or not on occasion, you know?
Right. But that the holes were created by them.
Yeah.
And if you'll remember, the pictures of the bathroom showed that they weren't properly using the restroom.
I'll never forget the pictures of the bathroom.
Yes, sir.
Indelibly imprinted. You have any suggestions of how I could forget that? No. Take those.
No, sir.
Well, this is a case, you know, I guess if y'all don't think anything else, I'll just rule on it, and somebody doesn't like it, you can take it up. You know, is there anything else you'd like to put in as far as damages? You got everything?
Yeah, if the court would enter an order allowing us to go on the property and get estimates as to what the repairs will cost, then sure, we'd like to have that and be able to present that.
Well, if you could go on the property and get a reduction of some sort or an offset of some sort, would your clients be willing to let them stay on the property, or they just want them off?
I believe they want them off, and it's my understanding that they've actually vacated back in the spring. And that
Your clients don't want back on.
If they did vacate, I'm sure they don't want it back on. There were threats and people driving by shooting guns, and I don't think they felt very safe there.
Have you made any kind of cash offer to
No, sir.
anything?
No, sir, because we were waiting on the ruling after the trial.
Well, the ruling is going to be that the contract was good, and we don't know what we're going to do after that. You know, I don't know what the right thing to do on it is. You know, I mean, it was kind of set up at $150 a month or something like that so, you know, you could count the days that they occupied it and give you an offset for the day, you know, a reduction of that, but then.
I think one of our tendered orders actually had the amount at the time in it, so.
Yeah. What was that amount? You remember did you reduce it by the number of months? Is that what you did?
Yes, yes. So I just basically did the math from when they moved in until
I don't remember seeing that order.
I submitted two different ones, Your Honor.
I see your tie where you thought this could be trick or treat here today or something.
Hey, when you got a seasonal tie, you better wear it when it's in season.
That's right. I don't know why anyone would have a seasonal tie, but if you do have one, you wear it when it's appropriate.
It was $26,000, I believe.
Would you be entitled to?
Yes. Because I believe the lease was supposed to be good through 2030, something like that. So
Yeah, it was $150 a month, 30,000.
It was $250 a month, Your Honor,
250 a month.
for a period of 120 months.
Yeah. It's about 10
2033.
years, isn't it? Any way you cut it.
10 years from
Yeah.
2023.
Yeah, it was a 10-year lease.
Well, why don't you see with that reduction from the time they moved out back to reduce the 30,000, see if your clients would consider splitting the difference.
Yes, sir.
I mean, I think that's about the best you can do unless somebody wants to appeal it. You know, with the amount of money involved, either side that loses is probably not going to net very much if you have to appeal it.
Yeah.
Okay, well, I want to order that allow his clients to come in and inspect the property. And if they've already abandoned it, you need to notify him if they've abandoned it or not. If they've abandoned it, you can do what you want to with it.
Yes, sir.
If they have not abandoned it, then you need to provide an opportunity for them to come in and inspect with notice. Okay. In case your client wants to have someone, they probably wouldn't want to be there themselves, but want to have somebody there to make sure that no additional damage is inflicted on it or anything. Maybe take pictures before they go on. Okay. Does that sound like fair? Okay. Thank y'all very much.
Thank you, Your Honor.
Let's try to have this done by November the 13th so we can resolve this thing. Okay.
Yes,
okay. Thank y'all very much.
Thanks, Judge. That's all I have. Can I be excused?
Yeah. Have a nice day.
Thank you.
Yeah. Vanderbilt Mortgage versus Louise Creek, also known as Wilma Louise Carter. This is a motion to compel the warning order attorney to submit her report. In support, said that plaintiff states that Holly Coleman was appointed warning order attorney for the defendant, and as of this moment, has not filed a report. Vanderbilt Mortgage versus Louise Creek, known as Willa Louise Carter. Well, I hadn't checked the file. I'm just reading the motion. Could someone check the file? I mean, I could do like Mayberry. I could be attorney and judge. And 10-3. And this motion was filed. No, yeah, his motion was filed on the 1st. And then shortly thereafter, by coincidence, it was filed. I understand. Okay, well, there's no need to compel now. We'll just say it's filed, and we just make a docket notation of that. So Joshua Stephen Donahue versus Melanie Louise Law. Motion to withdraw.
Good afternoon, Your Honor. Olivia Craig appearing on behalf of Mr. Clark for his motion to withdraw.
Yeah. Well, you say it's the case is complete. Is that correct?
That's what I've been told, Your Honor.
Okay, you want, can I place you under oath and we'll ask you if the case is complete? I'm just kidding.
Oh, don't be mean to me,
Submit,
Your Honor.
yeah, electronically submit the order and we'll enter it. Okay, thank you very much.
Thank you, Your Honor, so much. Have a good rest of your day.
You also. Danny Joe Stinson and Emily Stinson versus Mackenzie Ryan Graves and Garrett Graves, and there's a companion case there, right?
Yes, Judge.
Which would be Ryan Millen. Let's come back up and get involved in this again. Okay.
Judge, I filed the motion that put it on today.
Yeah.
It was a motion for contempt due to lack of compliance with the order that we had agreed upon.
Yeah.
I know Mr. Wilson filed a motion yesterday. I've not had a chance to speak to my client about that since it was just filed yesterday. With regards to ours, which was timely notice, I assume that's the one we're taking up today. I don't know if we're gonna just have to take some testimony.
I haven't seen this motion.
We're gonna have to have a hearing on it, Judge. My clients weren't personally served on the motion for contempt. There was no show cause order entered. So I don't believe Ms. Coleman's is properly before the court. And mine was a companion and tied to her, so.
Okay, well, y'all gonna need a separate day to do this, it appears to me. Normally we would go out to November 13th, but it seems like to me we probably ought to do something before then. Without really taking it up, okay, what's your primary complaint? See if there can be some resolution.
Sure. Our primary complaint is that they have, the children have not come for their visits, more than half of the visits since we were here at the end of
And then there
August.
was said that one of the children didn't want to talk on the phone, didn't want to.
Not want to talk on the phone. I think what is happening is the other parties are putting the child on the phone for the child to say, I don't want to come, I want to stay here and play with so-and-so.
Yeah.
And we don't think that's appropriate. That's putting the child in the middle of things.
What do you say?
Judge, I say that I've got from September 1st till now phone records of both of my clients, and I can show that his client only called twice in that time.
And Judge, I have records that show the opposite and would actually lend credibility to our statement that we think they've blocked him. We have records showing all of these phone calls.
We've got the ones from we've got the ones from the carrier certified showing that there were no phone calls made. But two,
What about the visits?
the visits, the Thursday visits that are supposed to be happening are happening at the ball field with her children present, which they were not supposed to be. They weren't supposed to be for the first 3 months. He's instead coaching, to our understanding. And then the other visits, the children haven't been able to go, or he hasn't wanted to make them up, or that's to the best of my understanding. But the Thursday visits are the ones that, so the ball.
Okay, well, let's get our calendars out. I'm gonna tell you. If I find out anybody's violating my court order about these visits, these children are gonna be lucky to get out of this without being messed up anyway with all this stuff going on. If I find out, I'm gonna do something drastic. So everybody needs to take some prayerful consideration of what they're gonna testify to and whether or not they're gonna comply with these visitations, whether these children want to or not. Children are not gonna decide unless there's some compelling reason, and then the order has to be changed. They can't be, say, I don't want to go. They're calling over there and I don't want to go. It's not gonna cut it. You know, if they don't want to go badly enough, we need to have another hearing to decide whether they ought to go or not. They can't be doing this themselves. Y'all got your calendars with you?
Yes, sir.
And Judge, I would request to make sure that the Thursday visits are just with him and not with the other minor children. So.
Okay, well,
And Judge, they are, I think
we'll
they're,
hear proof about that
Okay.
later, and if you have proof that it's not that way, then I'll take some action on that too.
Mhm.
Go away.
What about, what about November the 3rd?
It's a Monday, Judge, correct?
That is a Monday.
What time, Judge?
Well, 10 o'clock. We surely won't take like hours and hours and hours to do this.
I have something in Barron County at 10 o'clock. I could do it directly after that or before it.
Well, we could do it at 1 o'clock. How about 1 o'clock?
That works, Judge.
Okay.
And I'm sorry, did you say to do it in Cumberland County?
I didn't say that, but I always like to do things in
I know you
Cumberland
did,
County.
so
Cumberland County closer for me.
it's probably equidistance.
Okay.
If I had to guess.
November 3rd at 1 o'clock in Cumberland County.
Yep.
Okay.
And Judge, I think the actual physical order maybe hasn't been entered. I know we did it, we put it on the record verbally. But if we could get that,
I think he came back.
Did it
Once
come
you,
back?
once you submitted it, I think I saw him,
Did you?
he signed it
Okay.
from, on December 3rd, I
Okay.
think, so.
December.
Or
Oh, I'm like-
October. Please, my wife is in the middle of a PET scan right now and I just
Like
had
I've
a
lost a
child,
month.
like.
Yeah, oh yeah, no, I think you might be right. Once with this was filed, I think you might be right.
Breast Cancer Awareness Week is
Yes.
very accurate for me.
Sure.
Let's see here.
Very aware of it.
That went somewhere else other than where it was supposed to go.
Well, we have a hearing on December 5th as well, correct?
I think you're right. So that didn't come out of nowhere.
That didn't find the right location.
See if they have them logged, is it gonna log the calls? It is, because I want to do some research on
Okay,
that, because I mean, these are most of these.
we
are
can,
fed-
I mean,
most-
we can trade discovery.
Yeah.
I mean, that makes
mean, most
more
of
sense
these-
to me,
Most of these are based, which I would assume maybe.
I would assume.
What you've got.
But hit info and let me see what the info says on whether or not how long it was. If it was canceled 0 seconds, whatever, it should show that.
Okay, now I want to just talk to everybody just for a second. We've got this set. This has got to work. Okay? Everybody needs to reflect upon this. We're going to do this. It's got to work. You're just costing yourself money, costing your time. Somebody could lose some position that they have now as far as the visitation. I mean, between now and then, everybody needs to do some reflection on what it would take to make this thing work. And we'll see y'all on the 3rd then, 1 o'clock, Cumberland County, right?
Thank you, Judge.
Okay, thank you very much.
Thank you, guys.
Oh, Jim, I can see you.
Mariner Finance LLC versus Cecil Hudson, a motion for summary judgment.
Thank you, Judge. Good to see you.
Thank you, yes.
Galen Gray for the plaintiff, Your Honor.
Cecil Hudson. This is a motion for summary judgment. What do you have to say, Mr. Hudson?
I admit I owe the debt, and April and May, I made $25 payments, but the past 4 months, I've made $100 payments.
The
And I've
total
got
amount of the
copies here I
judgment,
want to enter into court.
do what?
Got copies here I
Well,
like to
the
enter in.
problem is that they don't have to accept payments of that size because they're not making the payments according to the contract. Isn't that correct?
That's correct.
That's your problem there. Now, if I go ahead and enter a judgment, it appears to me that your main problem, what's the total amount after the interest is added to it?
As of June, it was 7868.94,
Yeah.
but then he has made some payments, so I think we're back down to around.
It was 72.90 at one time when you started, yeah. Well, have you got a payment? I'm gonna, and they're just asking for $500 attorney's fees, is that right?
Yes.
Which is a good deal for you, you know what I mean? Because they, a lot of the times they'll get like 30% or 20% or something like that. What we need to do is go ahead and enter this judgment and let them set up a payment schedule with you. And I'm sure they'd be glad to negotiate a payment schedule.
They have been, yeah.
Yeah, and that way you'll know what you have to pay and you won't have to be up here anymore. And of course, I don't know what kind of interest rate after that would be, what, 8% or something?
No, it's still at 24% contractually. So the
I
problem
know,
we're
I was
having
trying to
is,
work it with him, so.
oh,
I mean, would you?
well, the summary judgment still says 24%.
I know it does, but I was gonna say if you did, you could do a payment schedule with him or an agreement. To get payment at some juncture. Have you ever declared bankruptcy?
Yes, sir, I have.
How long ago was that?
It's almost been 7 years ago almost. It's been like five and a
Yeah.
half.
Okay. Well, this is probably not enough involved that you would want to do bankruptcy again, What would the payment, if you got an approximation of what the payments would be?
I think originally the payments were 200 and looking at the original contract here. So he had another debt that rolled into this one. It was 235.74.
Yeah. Well, I'll do the judgment, and so that would amortize it at that higher interest rate. Is that correct?
It was.
But he could also always pay it earlier, couldn't he?
He could have definitely pay early if he'd like.
It could now, though, too. It could. I mean, I'm thinking what the best deal for you to do is to try to borrow some money somewhere at a lower interest rate.
Know where I can get it.
Your Honor,
I understand that when you don't
Can I
pay.
approach?
Yeah.
Sorry, Your Honor, I practice in Tennessee. We have a
You can go back there and say he's got a right to hear whatever.
I don't want to give you legal advice.
Well, stand back there. I don't care to get advice.
Okay. In Tennessee, we have a slow payment plan that they can file with the court to reduce the amount that they pay per month. I just didn't know if Kentucky had that.
I don't know whether they do or not. I'm not aware of it, but.
A slow
if
pay
you-
form
if
or
you want
something.
If you want to, you can reach an agreement.
We couldn't. I tried to talk to them before court and they just told me to leave them alone. So,
Your people aren't willing to do this slow payment sort of thing with you?
well, they'll try, I'm sure.
Well, he's here to agree now. You make him an offer now. And
They want the 270. the original payment that was supposed to be being made, the two hundred
I
and
just can't
seventy.
afford that much per month. I mean, right now I'm working at Central States Metal and
Okay, well, I'll enter the judgment and here's what they're gonna do. They're gonna go after your check every month and they'll get the maximum amount if they garnish your wages. That's it. Okay, either that or you can reach an agreement at $200 and something a month and make that work. So,
I can do my best at it.
well,
All I can do.
you don't seem, it's not very convincing. I mean, I'll enter the summary judgment and y'all just go ahead and garnish it. Okay?
Thank you, sir.
Thank you very much.
All right,
Yeah.
thank you.
Dyer versus Matthews, motion to permit a survey. Haven't had one of those in a while. Who represents Mr. Dyer?
I'm Henry Powell. I represent Mr. Dyer.
And you represent,
She also represents Mr. Dyer.
who represents the Matthews?
David Cross.
Mr. Cross, are you online there? Y'all heard from Mr. Cross or? Tell me how this arose here. I was reading the motion last night and some of the pleadings that.
I'll let you explain.
The surveyors want permission to go on the property. There's been some concern about being on that property. And so they asked.
You said both parties claim ownership of portions of 128 acre property.
That's correct.
Originally granted to Mr. Probst. Okay, but how do both of them claim interest to it? Tell me how they're claiming interest.
Mr. Matthews claims interest through a series of deeds, 3 of which date back to this piece of property. One of those dates to this piece of property. And that was a Z-171 deed back in 1872 or something to Mrs. Beck that was for 32 acres of this 120 acres. The other 80 acres of it devolved into 2 pieces. One piece of that is now held by David Anderson, Anderson Lumber, and the other piece that's held by my client. In the course of time, John Monroe, not the president, but a different John Monroe, attempted to clean up the title of that. And in that, John Probst, who is the predecessor of Mr. Matthews, quit-claimed his interest in that surveyed property, quit-claimed his interest in that to John Monroe. So once we went back and established that chain of title, it appears to our contention is that we have clear title to that entire property, less the piece that Mr. David Anderson owns.
It were deeded to our clients' predecessors and interest before the defendants.
Was anybody been on this property any of that time?
Nobody has lived on this particular piece of property at all. It doesn't look like ever.
Mr. Cross's client says that somebody has lived on it for a period. There's no adverse possession situation.
No adverse, he claims through a survey that also overlaps a piece of my client's the 42 acres that's left of that property. He claims by survey to that.
You're claiming Mr. Cross's, who did Mr. Cross's client get the claim from?
His claim goes back to John R. Probst.
Who was his immediate predecessor title? I mean, he buy it? Did he buy it?
He did, he bought it. Subject to a survey from that's not the right.
Well, I just read an interesting new book, Land Surveys in Kentucky. Have you seen the book? It's pretty good. And it talks about we concentrate on meets and bounds when we should be talking about finding corners and finding monuments.
Finding coin. This one's pretty straight. That's what Mr. Lefkowitz told me. He said, the survey describes what's on the ground. It's not the other way around.
That's exactly right.
And so that led me to
You
figure out.
read that book too?
Yes.
It's pretty good.
He sent it to me.
Yeah.
Let's see.
The Doorbeckers.
The Doorbeckers.
I really like what it says about warrants and land grants. So, I mean, I really didn't down through the years, I dealt with that stuff all the time, but I never had thought about it globally. You know what I mean?
This one involves a land grant that is in error from the original land survey,
Yeah, from the.
which is,
From the warrant, probably. Was there
yeah,
a
the
warrant?
original warrant has an error in the transcription from what the surveyor did.
No, that's always good.
And so we got, Mr. Matthews got his title from the Doorbeckers back in 2007. And
Okay, well, I'm going to enter an order allowing them to go onto the property to try to find the monuments and that sort of thing, and to do a survey illustrating where the monuments are. And Mr. Cross is not here today, and so you just electronically submit the thing directly, and we'll give it on. You can send it to him first to see if he wants to object to it. I don't see where he has much of a grounds to object to letting them enter onto the property. Now, and when you get to that, are you going to want a bench trial or a jury trial? Or are you going to do a summary?
we'll want a bench trial
Yeah.
unless we can agree to.
Yeah, okay, that'll be fine.
What's your spring look like?
Spring? Well, I mean, I'm at my particular stage in life, I'm hoping I'll be here in spring.
Well, I'm hoping you'll be here as well.
We never know how our spring's gonna be. But I got a pretty open sort of situation, and we probably would want, we do it in Cumberland County sometimes, so I can have my staff lawyer monitor and do other things. It shouldn't take a long time. I mean, fortunately, unfortunately, I spent a lot of my life doing oil and gas title work back to the original. So I mean, I understand things fairly well, but I can be confused. Don't get discouraged. You could confuse me.
This one was an educational exercise for me to see if I could actually.
Well, when you do, I did all the division orders and transfer orders for all the crude oil that was bought in Kentucky and Tennessee for Delta Refining Company, who later were bought by Williams. They were a refinery down in Memphis. So I did all that stuff, and I've seen every kind of title opinion, every kind of exception, and that. But the main reason I did it is because most of the other lawyers did not. I got the contract because they couldn't convert fractions to decimals. It scared them, And I guarantee none of the young lawyers could do that probably now. But there's probably an AI program that would do it for them. So
you can convert poles to feet. You got it made.
Oh yeah, and get these people that were doing it by. The correction to the true north, and then they had these hip, boot, and chain surveys where they were stepping off. It's pretty interesting. Well, thank you very much.
All right, thank
Good
you.
talking to you. Yeah. Okay, we got MPLI Capital Holdings versus Amy Page.
For the plaintiff, Your Honor, this is another motion for summary judgment.
Okay, the defendant is properly served. Is that correct?
Yes, sir.
Check the file, make sure we got proper service in that. Did they file an answer?
Not that I could see, sir.
Well, it said here that evidence record consists of the plaintiff's complaint, defendant's answer, plaintiff's request for admissions. And then evidently they didn't file answers to request for admissions. Isn't that right?
I think we requested the admissions and they didn't.
I know they didn't file,
Yeah.
they didn't respond, but then to the request for admissions. Is there an answer filed in that?
My glasses only work far away.
Who filed? Was it filed by an attorney or was it pro se? What's that? Is it an attorney? And are the requests for admissions after that? That answer was filed by the defendant.
To see, was it what haven't they answered that I'm here for? I'm sorry, I'm an appearance attorney. If I seem dumb, I promise I'm not.
No, you're here, you want a summary judgment.
Yes. Yes, because there's not any facts left.
You made a request for admissions.
Right.
And they did not respond to it, so they are deemed admitted.
Right. Which is why since there's no facts left in question, that's.
I understand that.
Yeah.
The notice and that
That was the request for admissions.
It is a notice for summary judgment.
Yeah. But before that, were there requests for admissions? Well, there is a notice of service of discovery request.
Yeah, I have
Given
that
on
as
the
well.
24th day of April in 2025, mailed to Amy Page rather, Summershade. But they're not, I don't see anything in here. Yeah, here it is, right before it, excuse me. Yeah, there it is. First set of interrogatories, okay. You submit an order electronically.
Yeah.
Okay, thank you.
Thank you.
Mhm.
Or this payment's over for this person, so I'm gonna put it back there.
JBL Advisors LLC. Motion to default summary judgment order of sale. It's one of your tax liens.
Not mine yet, but yes, matter of fact, these liens go back to 2016, so.
Yeah. And you're just adding some parties here, is that what you're doing? Unknown heirs of Carol, you don't, is this abandoned property or something, or what is it?
This woman, actually Jimmy Borders sold this land to her and moved away, was notified that she had died. Tax bills have never been paid, and it's sitting right next to his land. It was actually carved off of his farm, so.
Yeah. Okay, submit the order.
Should be in.
Will it bring enough to pay it off, or is it upside down?
It's hard to say on that, Your Honor. I'd say it'll be close.
Does the master commissioner get to sell this? Is that right?
Yeah.
Are you familiar with the property?
Only from this action, I reviewed the report.
Yeah.
One appears to have been, through a Rule 404 bond since they were constructed.
Okay, submit order.
Thank you, Your Honor.
That concludes the docket except for the adult matters, the juvenile matters that are off the record. Is that correct? And what time are they scheduled for? Yeah, and none of the parties are here. Let's go. Can you get me off the record here?